Welcome to Bcast, Benesch's business law videocast series. This is where we discuss the most topical legal and business issues. In this issue, we're going to be talking to Marc Blubaugh, a partner in Benesch's litigation practice group. Today, host Janet Feldkamp is going to talk with Marc about transportation law updates.
Hello, I'm Janet Feldkamp. I'm a partner in the healthcare practice group located in Columbus, and here today I'm with Marc Blubaugh. He's one of my partners in the litigation department here in Columbus and the co-chair of the Transportation and Logistics Practice Group. Marc, it's nice to have you here today.
Good to be here.
And we're going to talk about transportation and logistics law, an update. So I know there's always many things that are going on in this area, but let's kind of talk about what kinds of regulatory things do you think are front and center right now for your clients in this industry?
The real hot issue right now is compliance with last year's highway bill that came out. Last summer, the President signed the new highway bill into law, and there are some effective dates that are coming up. This law is known as MAP 21. One of the big issues that our clients are wrestling with right now is that the law contained a wave of changes for motor carriers, transportation brokers, and freight forwarders. One of these specifically relates to a motor carrier's ability to interline freight to other motor carriers. Prior to this law being enacted, there was really a split in authority, a split in legal opinion really, as to whether or not a motor carrier could do this without having transportation broker authority. There was one school of thought that said no and would point to FMCSA's website and some of the Q&As that appeared on that website. Another school of thought said it was okay because the definition of a transportation broker excluded a motor carrier, and there was a 1951 ICC decision that supported this notion of convenience interlining. The new law, however, makes it pretty clear that a motor carrier has to have transportation broker authority if, in fact, they're going to interline freight without touching it. If they're touching the freight in some fashion, they can proceed to interline it. So in any event, the bottom line is that this change is motivating a number of motor carriers who do engage in an appreciable amount of transportation brokerage to go ahead, or at least who engage in an appreciable amount of convenience interlining, I can say, to obtain independent brokerage authority for that motor carrier entity to ensure compliance. And one of the reasons it's important to them, and one of the reasons it's motivating them, is that there is now a $10,000 civil penalty per shipment for any unauthorized brokerage. And moreover, any liability that might arise from unauthorized brokerage can give rise to civil liability, private cause of action from another party, as well as individual liability for the directors, officers, and principals of that entity. So it's created a lot of angst in the industry and has motivated a lot of folks to begin submitting brokerage applications before the critical deadline of October 1st, 2013 arrives, which is really only a few weeks away. So that's really the hot issue, I think, on the regulatory front right now.
Wow, that sounds very interesting and very important to this industry. So what about some recent court cases that really deal with the transportation and logistics company that our clients need to be aware of?
Yeah, there's two that come to mind right off the bat that are recent decisions. One is from a federal appellate court just earlier this month relating to the hours of service regulations that govern motor carriers. This has been an issue that's been ongoing for years and years, really about 17 years since there was a significant change in the hours of service regulations. Last January, the new regulations were rolled out. They became effective just this summer, July 1st. And they were the subject of many court challenges. Really, the industry was challenging the rules on the notion that there was an automatic restart provision that was a bit complicated and onerous. The self-styled safety advocates were challenging the regulations on the notion that they didn't go far enough, that they didn't reduce the driver time or drive time from 11 hours to 10 hours. This has been tied up in court for a long time. Well, in any event, August 2nd, the court finally issued its decision, and in large part really upheld the hours of service regulations. The 34-hour restart provision that I mentioned was upheld. Likewise, the agency's decision to keep the driving time at 11 hours was upheld. There was one minor provision that was essentially struck down, and that relates to short-haul drivers that really are not going to be subject to a 30-minute break time during an 8-hour day. Court found that the agency really hadn't made its case as to why that was going to be necessary. Short haul is really unique, kind of a unique function in the industry, and these drivers, at least who have CDLs and who operate within a 100-mile air radius, as long as they're keeping some kind of time records and return to work within 12 hours, are not going to be subject to that break period. And it's a 150-mile air radius for those who don't have CDLs. So that's one significant court decision that has dramatically affected the industry. There's a lot of concern about what implications these new regulations have for the efficiencies of various clients' supply chains. You know, how are they going to get things done? We already have a driver shortage, and the reduction in driver time can really have an impact overall on the functioning of the economy. Another decision that's significant is one that was issued by the U.S. Supreme Court this summer, and we don't have many transportation cases that make their way to the Supreme Court, so when they do, they're significant. And this related to the efforts by the Port of Los Angeles to govern the trucking companies that are doing business at the port. Essentially, they were requiring trucking companies to sign a concession agreement, which included a whole host of different provisions in order to perform their services at the port. A challenge was brought to these concession agreements based on the Federal Aviation Administration Authorization Act, a big mouthful we call the F4A, a preemptive statute that essentially says, look, if you're going to regulate the rates, routes, or services of a trucking company or a transportation broker or a freight forwarder, those efforts are going to be preempted with a few exceptions. This litigation has been going on for years, challenging different types and components of these concession agreements. Well, finally, the U.S. Supreme Court spoke this summer and struck down several portions, the remaining portions of these, two remaining portions of this concession agreement. One related to the obligation to placard your trucks with certain information, and another to submit off-street parking plans. The court essentially said, look, this amounts to regulation of the trucking industry. It is not the port acting as a market participant here, but rather as a regulator, and struck down those efforts and really affirmed the breadth of this F4A preemption. And it's a significant win for the industry because the uniformity and regulation across all of our states is so critical to the prosperous functioning of the transportation industry. So that was a significant court decision as well. And there's some efforts in Congress to really kind of undermine that, and that people in the industry need to be aware of, that there's legislation being introduced to carve out certain exceptions to this preemption, which can really undermine the purpose of uniformity. So those are two significant court cases that I think people need to be aware about.
Those really are some significant cases for the industry. But what kind of industry trends may have caught your attention recently?
You know, I think the most significant trend is one that has been emerging for quite some time, and it's really the proliferation and the integration of various service offerings by a single provider. You know, once upon a time, trucking companies did trucking, warehousing companies did warehousing, transportation brokers did transportation brokerage, but more and more, these companies are providing a whole cafeteria of services. Warehousing companies are getting into trucking and transportation brokerage. Transportation brokers decide they want to get into warehousing. And there are great opportunities for those involved in transportation and logistics to capitalize on that trend and to make money at the end of the day and provide a better quality of service and a more integrated service to their customers. And there are also some risks that those companies need to be aware of. Too often, I see a company that decides to enter into a new service offering and is really merely mimicking something they saw in the marketplace, and they haven't thought strategically about how they're approaching it. And they may not have gotten the appropriate operating authority from the federal government. They may not have implemented appropriate contracts to really manage their risk as they enter into this new service offering. And so while there are great opportunities with this trend, there are also some risks that clients and businesses involved in this space need to be aware of and be sensitive to. You don't want to be, you know, there's the old saying, you know, an ounce of prevention is worth a pound of cure, and there's a lot of truth into that. We don't want to see people in this industry get blindsided down the road, rather be proactive and take those steps necessary to have a successful, prosperous business at the front end.
Well, thanks, Mark. You brought some really interesting information to our clients today in the transportation and logistics area.
Happy to do so.